The Supreme Court yesterday delivered a landmark ruling abolishing the mandatory death sentence, terming it as unconstitutional. In the ruling by Deputy Chief Justice Philomena Mwilu, Justices Njoki Ndongo and Jackton Ojwang, the country's apex court said Section 204 of the Penal Code was contradictory to the Constitution and quite discriminatory. The judges had to look into Section 204 of the Penal Code to determine whether it was in tandem with the Article 19, 20 and 38 and 48 of the Constitution, which talks about justice for all, human dignity, fundamental rights and equality to the law to all, alongside Article 52 of the Constitution.
Section 204 of the Penal Code deprives the court of the use of judicial discretion in a matter of life and death. Such law can only be regarded as harsh, unjust, and unfair. The mandatory nature deprives the court of their legitimate jurisdiction to exercise discretion, not to impose a death sentence in appropriate cases.
The mandatory nature of the death sentence, as provided under Section 204 of the Penal Code, is hereby declared unconstitutional. For the avoidance of doubt, this order does not disturb the validity of the death sentence as contemplated under Article 26, Sub-Article 3 of our Constitution. We direct that this judgment be placed before the Speakers of the National Assembly and the Senate, the Attorney General and the Kenya Law Reform Commission, attended with a signal of the utmost urgency for any necessary amendments, formulation, and enactment of statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters of what ought constitute life imprisonment.